Please be seated. We'll hear argument in 2725. Van Dohlen against the City of San Antonio. Justice Lehrman cannot be present this morning, but expects to participate in the decision of the case.
May it please the Court, Mr. Mitchell will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the Court. Section 2400.004 of the Texas Government Code clearly and unequivocally waives and abolishes governmental immunity in any lawsuit that seeks declaratory or injunctive relief against a defendant that is alleged to have violated Chapter 2400 of the Texas Government Code. It is undisputed that the plaintiffs are seeking declaratory and injunctive relief against the City of San Antonio for the actions it has taken and continues to take that exclude Chick-fil-A from the San Antonio airport. It is likewise undisputed that the plaintiffs have alleged that the city is violating Chapter 2400 of the Texas Government Code. It is therefore impossible to escape the conclusion that Section 2400.004 waives the city's governmental immunity and allows the plaintiff's lawsuit to proceed. The Court of Appeals held that the plaintiff's lawsuit was barred by governmental immunity, notwithstanding the clear, unambiguous, and unequivocal waiver of governmental immunity in Section 2400.004. The Court of Appeals holding is wrong and should be reversed. The city cannot assert a governmental immunity defense in a case where governmental immunity has been waived and abolished by statute. The court should also hold that the plaintiffs have standing to sue the City of San Antonio over its exclusion of Chick-fil-A. The Court of Appeals did not reach this issue, but the district court did. And the court should not remand this issue back to the Court of Appeals and risk another ruling from that court that defies the clear and unambiguous language of Section 2400.004.
We felt that the plaintiff in some cases has the burden to plead and in some cases even submit evidence to establish a waiver. Even if the generic pleading is a waiver, the facts pled must support that waiver. I'm thinking of the recreational use statute cases. So for example, if I sue the city for striking me with a motor vehicle and therefore there's a waiver under the Tort Claims Act, but the facts pleaded say I was hit by a bicycle, courts are going to look at that and say there's no waiver here because
right.
The facts undermine it. It's not so much the merits, it is still pleading based, but the pleading defies the waiver. Does that concept apply here for your situation? You've pled this, but the nature of the facts you've pled, according to the city, is you're applying the law retroactively and it fails on the merits, and therefore there's no waiver of immunity.
Right.
Why doesn't that apply here?
Well, everything you said, Your Honor, is correct, but in this situation, all we need to establish a waiver of governmental immunity is an allegation that the city has violated or is violating Chapter 2400.
Even if the facts you plead that support the allegation plead yourself out of that claim.
Well, we haven't in any way pleaded ourselves out
because they argue you're trying to apply it retroactively. I'm not saying I agree or disagree with them. I'm just saying if they're right on that, why doesn't that affect immunity waiver?
If our argument was that the city violated Chapter 2400 before the statute took effect, which is what the city is attributing to us, if that were our argument, and it's not, but if it were, then clearly we would have pleaded ourselves out of court. But
because of immunity?
Well, because of immunity,
merits.
Both. I think both. Because
so you would concede that if this, if we characterize this the way the city is, then there's no waiver of immunity. It's not just you lose on the merits. There's no waiver of immunity.
We would have to identify some other waiver of immunity. The only way we can rely on the waiver of immunity in Section 2400.004 is to allege a violation of the statute that occurred on or after September 1st, because the statute was not in effect before September 1st. And this is one issue on which the city and we agree. I mean, the statute is not retroactive. We're all agreed on that point. The city did not violate the statute when it adopted the Trevino Amendment because it enacted and adopted that amendment prior to September 1st, 2019. So we're all agreed on this point. The city did not violate state law by enacting or adopting the Trevino Amendment by a vote of the City Council. The violations of state law come from the actions to implement the Trevino Amendment that occur on or after September 1st, 2019.
Are there any?
Well, we have alleged that in our complaint. We filed our complaint on September 5th, so 5 days after the statute took effect. And what we have alleged in the complaint is that the city, I'm sorry.
So we don't know if there are any.
We'll find that out in discovery, but at this point, at this stage of the litigation, at the pleading stage, the allegations of our complaint need to be accepted as true when the city moves to dismiss under Rule 91A. And on the plea to the jurisdiction, all we have to show is an allegation. Because again, if we look at the text of Section 2400.004, all that's needed is an allegation of a violation to get around a governmental immunity defense. Now, of course, you can't just win your case on an allegation. That goes to the merits, that comes later. But
What violation is alleged?
the violation is that they are taking actions to implement the Trevino Amendment. So the statute prohibits any adverse action that is partly based on an entity's support for a religious organization. So any action that is taken to put a replacement vendor in that spot.
But
that would
what actions have you alleged?
Well, we haven't specifically alleged actions in the complaint yet because we haven't taken discovery. So we've alleged that they're implementing the Trevino Amendment. We're alleging that they're taking actions to implement the Trevino Amendment. What exactly those actions are will come out in discovery. So who is the replacement vendor? We don't know that yet because there hasn't been any factual development. There hasn't been discovery at this point. The city moved under Rule 91A. The city filed a plea to the jurisdiction before we ever got to that point. But
you can take discovery on a plea to the jurisdiction, but was that not requested by either side in the trial court?
No, it was not, because again, our position on the governmental immunity issue, Justice Busby, is that the mere allegation is enough. If you look at the text of Section 2400.004, governmental immunity is waived and abolished to the extent of liability established by Section 2400.003. And then in the previous sentence, the first sentence, says that any person who alleges a violation of the statute may sue. So that's all that's needed to get into the courtroom door.
It seems like our rules for statute of limitations and accrual and that sort of thing should be considered in the mix of deciding when a violation occurs. And we've said, basically it's when you can sue is when a violation occurs. And so there's not, it's not like continuing tort theories are fairly rare in the limitations context. And
Right.
so help us understand how your argument fits with that general rule that a violation, just because you're continuing to be harmed by a violation doesn't mean that the thing that you can sue over hasn't already happened sometime in the past.
Yeah, I think with respect to the statute of limitations, Justice Busby, we filed our complaint on September 5th.
No, I'm not saying there's a limitations argument in this case, but what I'm saying is the principles of accrual that govern statute of limitations, it seems like would also be relevant in deciding whether the thing that harmed you occurred before the statute was enacted or after.
I think that's certainly right. We can only sue over conduct that occurred after the statute took effect.
Right.
So again, the statute was enacted before September 1st. It takes effect on September 1st, 2019. There is nothing we can do about any pre-September 1st, 2019 action to obtain relief from this court. We cannot.
Is there any new injury that occurred after September 1st?
The question, I think, Justice Busby, is was there a new action that occurred after September 1st? We don't have to show injury under the statute. All we have to do is allege a violation of the statute, whether that injures us or not.
So was there a new violation after September 1st?
Yes, we've alleged in our complaint that the city is taking actions to implement the Trevino Amendment. We don't specify in detail what those actions are, but that level of detail is not necessary under a regime of notice pleading. And anything the city does, adverse action is defined very broadly. Any action, typing an email would be an action. Picking up the phone, negotiating with a replacement vendor would be an action. Looking for a replacement vendor would be an action. Any type of movement would be an action. Anything the city did to put a different vendor in that spot that would have gone to Chick-fil-A is an action to exclude Chick-fil-A from a property. It's an action to deny Chick-fil-A a contract. All of that falls within the definition of adverse action. And all of that they all constitute actions on which our plaintiffs can seek relief. Declaratory relief, injunctive relief, plus costs and attorney's fees. But again, the issue here is governmental immunity. That is the issue that the Court of Appeals relied upon in saying that our lawsuit could not proceed. And that is patently wrong because the statute, by its very terms, says the governmental immunity is waived and abolished to the extent of liability created by Section 2400.003. So there's no way to defend what the Court of Appeals said, which is this lawsuit is barred by governmental immunity. And then the only remaining issue in this case is the issue of standing, which the Court of Appeals did not reach. The district court did resolve the question. But the city will say on remand that our clients lack standing. And we believe it's prudent for this court to say right at the outset that that argument is a non-starter for two separate and independent reasons. Number one, the statute confers standing by its terms on anyone who simply alleges a violation of the statute. It's not necessary to show injury in fact. And the city's argument is based on the rules that apply in federal court, where injury in fact must always be shown under Article 3 to establish standing. That's not the rule in state court. In state court, if there's a statute that purports to confer standing on individuals who merely allege a violation, the courts must accept that and confer standing according to what the statute says.
And that certainly was our approach when we had a common law standing regime in Texas before we sort of constitutionalized it and adopted the federal constitutional understanding of standing. But is that still, is some of that common law standing regime still left? And if so, what shows us
Yes.
that?
No, absolutely, Justice Busby. It's still left. I mean, the court's precedents have made clear that if standing is conferred by statute, that the courts are to look to what the statute says with respect to who has standing to sue. In the absence of a statutorily conferred cause of action, then the court would apply the similar test the Supreme Court uses, the injury in fact, causation or traceability, and then redressability. But those three requirements are only needed in the absence of a statutory cause of action that explicitly confers standing on the plaintiff.
The statute doesn't use the word standing or explicitly confer standing, nor does it say anything about injury. It just says any citizen can sue. I mean, am I
That's
correct
correct.
about that?
Yeah, the word standing does not appear in the statute.
What if it's not ripe?
Ripeness would be a separate question,
Why?
but
Any
standing and
citizen
ripeness-
can sue to, any citizen can sue to
Right.
seek a declaration or injunctive relief against a violation. That doesn't require ripeness.
I don't believe it does, Justice Boyd. That's
So
right.
So the statute would allow someone to sue even if it's not right.
I believe so. That's correct. As long as they're alleging, they have to allege a violation of the statute. That's enough to confer standing. Again, doesn't mean they win, doesn't mean they get relief, but it's enough to get you through the courtroom door. The mere allegation of a statutory violation is enough, as long as it's done by a person. Any person who alleges a statutory violation may sue. That's all that's needed. Those are sufficient conditions to overcome
Well, it's
standing.
even a little broader than that because it allows you to seek injunctive relief to prevent a statutory violation.
Correct.
Which is what raises the ripeness issue in my mind here, because you've alleged that they have taken and are taking since September date, actions, but not alleged any specific actions. There could be a ripeness issue here. There could be some question about whether, well, they intend to or they're thinking about it, but they haven't done it yet, right?
Yeah, there could be,
Raises a
right.
ripeness issue, and it would be your position that this statute allows them to sue even if it's not right.
Well, it allows them to have standing to sue. That doesn't mean they
No.
get the injunction, right? There are many other ways they may be denied relief ultimately at the end of the day. And one way, in order to get an injunction, you have to show the harm is imminent, or you wouldn't show harm to yourself, but you would have to show the statutory violation is imminent, and if there's a lack of imminence, then there would not be a basis for issuing the injunction. You have to show essentially either a past violation, a present violation, but if you are alleging a future violation,
But the statute
there's-
doesn't require ripeness. It doesn't have, the statute
Right.
doesn't require an imminent violation. It
That's
just
true.
says you can sue to stop a violation.
That's true, but there are rules governing injunction. Yeah.
Constitutionally, we know that we have to impose the ripeness requirement so that we're not issuing an advisory opinion when in fact there's not about to be a violation, right?
Oh, that's right,
The
yes.
statute doesn't change that, so why does it change the standing requirement? It doesn't say you can do it even if there's no standing.
Yeah, but Your Honor, with respect, I don't think the issues you're discussing go to issues of ripeness or standing. It goes to whether you're ultimately entitled to an injunction. I mean, there's a well-defined standard for getting an injunction. You have to show that they're about to violate the statute. You can't just do it based on rank speculation. That wouldn't be an issue of standing. That would be a question of whether you're ultimately entitled to get the injunction. Because, again, this is a citizen suit provision, right? It's not requiring you to show an injury to yourself that the court will redress. It's a
Let me ask you
provision.
about that, because it does, should or shouldn't we interpret a person in 003 as a reference to the person in 002 against whom an adverse action is taken? Because it seems like, at least the other side's argument is that's the legal interest that the statute is protecting, is you've been, an adverse action has been taken against you because of your support to a religious organization.
Yeah, I just don't think, Justice Busby, that's a plausible reading of the statute. And again, I'm looking at the language itself in section 2400.004. It just says a person who alleges a violation. It doesn't say the person who suffered an injury or the person in 2400.003. There's no cross-reference in the statute. A person means any person. It doesn't have to be a specific type of person or any type of individual who's had an injury or is any way infected by the statute.
But that a person who is not the person in 002 can't get declaratory or injunctive relief, it would seem, without at least making the person who was injured under 002 a party to the case.
May I answer? I see my
Yes.
time has expired. Justice Busby, there's no need at all to make Chick-fil-A a party to the case. This is a citizen suit provision where the entire citizenry essentially has been authorized to bring civil actions against individuals who violate this law. And that's
So
the
the trial-
enforcement mechanism.
So the trial court could enter an injunction saying you have to, against the city, saying you have to put a Chick-fil-A in there, even if Chick-fil-A were to say, we don't want to be in there anymore.
So that's an interesting question, Justice Busby. To get back to your earlier question about whether Chick-fil-A has to be a party, Chick-fil-A does not need to be a party because the injunction is not directed at Chick-fil-A. The injunction would be directed at the city itself. So as long as the
But it
entity...
affects Chick-fil-A's interest.
It does affect Chick-fil-A, but they still don't have to be made a party because Chick-fil-A is not being told to do anything by the injunction, right? Chick-fil-A is not being said to operate an airport in the city of San Antonio on pain of contempt. It would be the city to whom the injunction is directed. Now, again, Justice
Yes.
Busby asked the second half of the question, what would happen if Chick-fil-A says, we don't want it? The question would then become, is there an adverse action? Because if Chick-fil-A doesn't want in, they really haven't been excluded, or they're not presently being excluded by a city that says, we don't want you anymore, right? So the key word in the statute is exclude. Now, if Chick-fil-A was excluded prior to that point, we still would have a cause of action under 2400.004. And I'll save the rest of my time for rebuttal.
Any other questions? Thank you, Mr. Mitchell.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Lane will present argument for the respondent.
May it please the court. It takes more than just to shoot first and ask questions later to trigger the waiver of immunity under this statute. Before I wade into the thicket of issues related to standing, I want to suggest in two simple steps why this court should affirm the Court of Appeals decision. First, we like Section 2400.004. It's Exhibit 1. I've distributed it so that you can look at it. It provides a limited waiver of governmental immunity. It's Exhibit 1 for your convenience. In substance, it says, a person who alleges a violation of Chapter 2400 may sue for the relief provided under Chapter 2400. Enough said. Key language, a person who alleges a violation may sue. To quote the Chief Justice in City of Laredo, we must take statutes as they are written, and the one before us is written quite clearly. Second step, let's look at the original petition that plaintiffs filed. It is the test for the standing and for the violation and for the waiver, and it's also been marked as Exhibit 2 and distributed. The factual allegations in the petition are found at paragraphs 20 through 47. They begin in 2011 and they end in March 2019 in paragraph 47, where it says the council voted to approve the airport contract. That's the last factual allegation in the petition. By the way, it's not enough to allege violations as a legal conclusion. The factual allegations end before the 6 months or more than 5 months before the effective date of the statute. The plaintiffs concede that vote.
Does the city disclaim an intention of enforcing the contract in the future?
Disclaim an intention of enforcing the contract.
I mean, their position is, we're alleging that you're going to take actions in the future. You intend, there's a threatened violation by the enforcement of this contract. Is your position factually, no, there isn't? Or is your position just, well, they haven't alleged that with enough specificity?
I will tell you that the city of San Antonio will comply with Chapter 2400 in every step it takes. Now, what the plaintiffs want you to believe is there's only one step that can be taken, and it requires a violation of Chapter 2400. But there are a multiplicity of steps that can be taken. For instance, the city of San Antonio could go back to Chick-fil-A and say, would you like to take the slot that was denied you in that vote in March of 2019? That would not be a violation of the statute. If Chick-fil-A was not available, the city could attempt to fill that vendor spot, mindful of its obligations under 2400, not to discriminate against anyone on the basis of their affiliation with or support for a religious
Let me see if I can
organization.
ask it differently. Their position is, your intention is to carry forward with the exclusion of Chick-fil-A. Is your position, no, it isn't?
No, it isn't. Absolutely not, Your Honor. As a matter of fact, since you've asked, it has been reported, and it occurred, that the city of San Antonio went to Chick-fil-A and said, would you be interested in coming into the airport and having the slot that was denied you in the vote? Now, that is not something that the city should have to prove at trial. It has immunity from suit. And so the fact is, yes, it was offered to Chick-fil-A, and now the city has to go forward not violating 2400 and find a replacement, mindful not to violate.
Just to be very clear, the city concedes that its ordinance is invalid and unenforceable to the extent it would permit the city or require the city to take an adverse action based on Chick-fil-A or any other entity's affiliation with contribution and so on. You agree the ordinance is invalid and unenforceable?
The ordinance was an approval of a contract between Parodies and the city with sub-concessionaires. It was approved on one date. It's not a ban of anyone. The city can turn around and get Chick-fil-A and have Chick-fil-A come in anytime it wants to and approve that contract. It's not a ban like in the city of Laredo. In the city of Laredo case, that was a situation where the city of Laredo passed an ordinance basically banning single-use bags at shops. The argument was that ordinance was precluded by a statute that had been enacted 15 years before. And before they actually started to enforce the ordinance, the Laredo merchants came and said, we want to get an injunction because this is a void ordinance. And here, they haven't argued that this ordinance, that this approval of a contract, not a ban, that this approval of a contract was void at the time it occurred.
So was this factual question of whether you intend to continue to exclude Chick-fil-A developed at all in the trial court, in the litigation on the plea of the jurisdiction?
No, Your Honor, and the reason why is, first, because the petition that was filed does not trigger the waiver of sovereign immunity, and therefore the city shouldn't have to defend itself. It's immune from suit. But the plea to the jurisdiction was based on the filing. That is still the filing, and was still the filing 4 months later when the court had the hearing and the ruling. There's never been an allegation, and it was even today, there's no allegation that the city has violated. And the fact is, there are numerous different ways. Let me, if I can, illustrate with an analogy. Let's say you, like me, drive to work every day up a street. You go through a cross street. It has no stop sign. Every day you've been doing that for years, like I have. Today, let's say this afternoon, the city installs a stop sign there. Tomorrow you get up ready to go to work. Before you even leave your porch, you're being ticketed for running the stop sign. Is that fair? The argument being, well, you've run that stop sign, you've run that intersection every day for the last 5 years. It's inevitable that you will do it again today. Well, there's a stop sign there today. You have a lot of choices. You can go the other direction, you can walk, you can Uber, or you can just come up to the stop sign and stop. And that's what the city of San Antonio will do. It has read Chapter 2400, and it will not award a contract that is not mindful of Chapter 2400. And if it's Chick-fil-A that wants to come in, Chick-fil-A can come in. There's no restriction on Chick-fil-A coming in.
And if it did, immunity would be waived from suit.
Only immunity is waived if there's an allegation of a violation of the statute.
No, you said the city will comply.
Oh, yeah.
But if they didn't,
Yes, Your
immunity
Honor.
would be waived.
Yes, Your Honor. If they said, we don't want to have this, specifically this entity here because they are affiliated with a religious group, and therefore we're kicking them out, and someone brought a petition the next day and said, we allege that they did it on this basis, that would trigger 004.
So the dispute between the parties here is not about the effect of the statute, whether it waives immunity, whether it prescribes behavior that it prescribes, but the only dispute here is with respect to this filing 4 days after the statute took effect. Can we be in court and argue about it?
Yeah, I mean, I would say even more fundamentally, we're in agreement on a lot of things. The vote didn't violate any law, okay? And to the extent that it cost someone the possibility of a Chick-fil-A sandwich, it was a lawful deprivation. That was the status quo ante.
It seems if your reaction to this case is we have no further intention of excluding Chick-fil-A and we agree that doing so would violate the statute, then it strikes me that maybe we need to remand to the trial court so that you can say that, and then that can be binding on you, or maybe the statements you're making in court today are binding and we can just say you've conceded that excluding them would violate the statute, and so we're done here.
Your Honor, let me be very clear. You're suggesting that we would have to defend the suit in the trial court. And our position, the city's position is that the waiver of sovereign immunity has not occurred.
Well, but it would have occurred if you had a future intention of continuing to exclude Chick-fil-A for this reason. And you're saying, and your response to that is we have no such intention. Chick-fil-A is welcome. And
I can say that
I
the
can see how that
contract.
might end the case, but only if you're willing to commit to it.
I can only tell you factually, the contract is amended without Chick-fil-A, was approved in March of 2019. In 2020, the Chick-fil-A was asked by the city if it had interest in coming back and having a slot in the airport. This was a matter of public record.
Has that record been developed in
And
the
Chick-fil-A
trial
actually
court?
it has not, because they didn't trigger the waiver of sovereign immunity that would have had us go through trial and have them ask witnesses and actually try and determine whether an actual violation had occurred. What was said up here was
Help me, because it sounds like you're saying the reason they haven't triggered the waiver is because you don't have an intention to enforce the contract.
Not at all, Your Honor. The waiver of sovereign immunity is based on the allegations in the petition.
Which are that you intend to enforce the contract.
What's that?
And the allegation is that you're going to do this. You're going to actually exclude Chick-fil-A.
They actually don't allege any. This court must do a searching examination of the record to determine whether there are allegations that trigger the waiver of governmental immunity. And here, there is no allegation that triggers it. Now, they say we want in the future to stop, and it's based on their theory that there's no possible way, and page 3 of their brief, they say, there's no possible way the city of San Antonio can do anything that doesn't violate Chapter 2400 now. And I'm telling you, there are multiple things that the city can do. This petition fails to trigger the waiver of liability, or waiver of governmental immunity, okay? And so that is our position. The facts that I'm recounting to you are absolutely correct. The Chick-fil-A made a public statement exactly on this point. Now, there are numerous other places nearby that can
There can be discovery in the trial court before the court rules on a plea to the jurisdiction if there are facts that are relevant to establishing whether there's been a waiver or not. And so why couldn't that be done if the allegation here, as it seems to be, is that the city's continued exclusion of Chick-fil-A is based on this, and your point is, well, we're not excluding Chick-fil-A anymore, then why couldn't there be a record developed on that, and either the trial court says yay or nay, there is a continued exclusion or not, and if there's not, then there's no waiver? Because
the city has the right to assert governmental immunity on the basis of this petition, which does not trigger a waiver of governmental immunity. I'm not saying, listen, if we are remanded, the facts will support the city of San Antonio. But the governmental immunity protects the city of San Antonio from having to defend this suit. and they haven't
If-
triggered the waiver of
If they have pled an actual or threatened violation of the statute and sought injunctive and declaratory relief and alleged that the violation was actual and threatened because the city has taken and is planning to take additional actions that violate the statute, but do not specify in their pleading what any of those actions are, does that waive immunity?
That's a lot to chew on, Your Honor, but I would say this, because you said if they say that it has been violated and that it will be violated. So let's start with first,
Well,
they
let's say
they have to,
has been after the effective date of the act.
under 004, it has to be there has to be an allegation, factual allegation of a violation of the act. There is not here. Now, let me just say this.
But
If
let me be real clear on the question.
Sure.
But what if there were, to your satisfaction, and they say there already is, but what if there was an allegation that the city post-enactment, September, whatever that date is,
September 1
of 2019,
of 2019.
2019, if the allegation is after that date, the city took actions and is still planning to further take actions that violate the act, and we want declaratory and injunctive relief to stop it, but they never specify in their pleading what those actions are, is that a waiver of sovereign immunity, a governmental immunity?
No, Your Honor, there has to be an allegation. It can't just be an assertion of a conclusion like that, or an assertion of an expectancy. There has to be an allegation. Otherwise,
How do you respond to Mr. Mitchell's point that these are notice pleadings, and I suppose that the city could specially accept to the pleading and ask that it be more particular in stating facts that constitute a violation after the effective date?
if they were suing me, John Q. Public, okay, that would be enough. But the fact is, to trigger to trigger a waiver of governmental immunity, there has to be an allegation. And the statute here says very specifically, you have to allege a violation. 004. Now, 004 is the key that opens up 003. An allegation of a violation of 002. And you heard many times up here during the first argument, we do not know that there's ever been a violation. We plan to, look for one, and darn it, we're going to find one, we hope. And I'm telling you that that's not enough to trigger the waiver of governmental immunity. And you're going to, if
Well,
that's...
you signed a contract that says you're going to do X, Y, and Z. And,
Yeah.
and their allegation is, we expect you're going to do X, Y, and Z, and we think you can't do that. I mean,
We signed a
that's not enough?
No, Your Honor, that's not enough. That is...
So how can they, without any discovery, without any further, can they get in your head and know what your intentions are and allege? What can they say other than, they've signed a contract that says they're going to do these things, we expect them to, and we want an injunction?
Well, what they don't need to do is rush to the courthouse 3 or 4 days after, with a long petition, after the effective date, before there's any indication that there's ever been any violation. Had they waited until for instance, until it was announced that Chick-fil-A had been asked to come back and to take the slot that had been originally denied it, well, would they even have filed this lawsuit? Certainly wouldn't have. That conduct wouldn't have triggered a waiver.
Has all that happened during the appeal?
Yes, it did, Your Honor. It did after the fact. But the problem is, the problem with this petition infects it before the appeal because it doesn't trigger 004. They don't allege a violation of the act. It's very simple. And I want to address in my few remaining minutes the standing issue. This court has repeatedly said that there are standing principles under the Texas Constitution that restrict access to court to those who are actually injured, okay? And advisory decisions and opinions are not permitted. This court has never dispensed with that requirement. And the question is, and the suggestion has been made, well, the legislature can dispense with it, but how does that work? It's a constitutional restriction on governmental action that this court has recognized again and again. Just last year, when
Well, the court said this court said in 1966 that the legislature may grant a right to a citizen or a taxpayer to bring an action against a public body or a right of review on behalf of the public without proof of particular or pecuniary damage peculiar to the person bringing the suit. That was Scott versus Board of Adjustment. And I understand there are later statements of the court that speak of this in terms of constitutional terms, but do we need to overrule Scott versus Board of Adjustment and several other cases in order to agree with you?
Not at all. That's actually the particularized injury is what the legislature can do away with. They can say everybody can sue, bring a taxpayer suit, even though you are affected just like every other taxpayer. The particular, you don't have to show that you are. Usually, when you challenge governmental action, a plaintiff has to show that they are affected by the governmental policy in a particularized way. Okay, that there is different. But when this legislature can say, we're going to dispense with the particularization requirement, but what they cannot do, the legislature cannot do, is dispense with the actual injury in fact. The plaintiff has to show that they're injured by the action. Here, the plaintiff...
There are environmental statutes that allow citizen suits, or those?
There's a lot of standing law on that, on those topics.
In federal court.
Yes, and Lujan is, Justice Scalia's decision in Lujan is a notable one that this court has relied on, and it says you have to show concrete injury. Okay, so there has been some movement in terms of that, but there are suits, and I'll just say the TransUnion case, which was decided 2 months ago. The TransUnion case was a case where the Congress had said you have an action if there's a violation of this credit reporting law. And a class of 8,000 plaintiffs brought suit, and they said, they violated it, we'd like, to get our remedy. And the Supreme Court said, but you weren't harmed. You have to have a concrete injury, and therefore those who, even though there is a violation under the statute, you have to show harm. And that's an indispensable element of standing. I would just say a couple of things on the requirement.
My point is, we've never had occasion to address squarely these many cases like this one that say that the legislature can dispense with some of the standing requirements.
Particularized.
To square that with some of the later statements that adopt some of the federal standards for standing. And I just wonder, if we're going to try to blend the two, I don't know that we have an option other than to just say it's all been wrong about the legislature's ability to grant standing. That's one way of blending them, but that's throwing away an awful lot of...
My time is up, Your Honor. May I respond?
You may.
Okay, so there's a floor of injury that everyone must show. There must be some injury. Now, every plaintiff to access the courts must have some injury. Now, when challenging governmental action, usually an individual must show particularized injury. In other words, what you're doing, government, is affecting me different than every other citizen. Because if it affects me just like every other citizen, ordinarily, I just have to vote against you or vote for somebody else. But if it's particularized harm, you've mowed over my property, you've done something that harms me particularly, they can come into court. Now, what the government can do is pass a statute that says we're going to take away the particularized requirement, but it brings it back down to that floor, that threshold injury requirement. The court can't dispense with that either in federal court or in state court because it is a constitutional restriction. Now, the Constitution could be amended to permit it, or our Constitution could be permitted to amend it, but there is an injury requirement. That is not a difference between those two line of cases.
So
they're entirely consistent.
Just to respond briefly, the same case from 1966 says the citizen shall not be required to show that he is personally injured by the acts complained of.
Well, in another...
It seems to be talking about injury generally.
In another...
We're going to have to... We've got these cases, we've got the newer cases, we're going to have to figure out how to blend them somehow.
Well, Your Honor, if it did say at another point in the case it referred to the requirement to show particularized that there are just numerous case after case. Heckman, N. Ray Abbott, this year, what was it, the Chiropractor Board versus Texas Medical Association. Every one of them has stated the requirement that there be an injury under the Texas courts provision. It's a restriction on governmental action. That I don't believe that case needs to be reconciled with those cases, because I think it really addresses particularized injury. But I think it would be an immense departure to say that this legislature can pass a law that evades the constitutional requirement of showing injury.
Any other questions? Thank you, Mr. Lane. Mitchell, you have 5 minutes.
Mr. Mitchell, if I may,
Please.
the city's council has basically said, we respect the new statute, we're going to comply with it. We have been complying, and we're going to keep complying with the new statute. Is it your client's position that the only way they can make good on that promise is to undo the amended contract?
Our position, Justice Boyd, is that if they took any adverse action after September 1st, 2019, we're still entitled to relief, even if they represent to this court that they will no longer take adverse actions against Chick-fil-A.
Right, but that doesn't address, I'm just trying to understand, does your client think that the city somehow has to undo the amended contract?
No, it's not that they have to undo the amended contract. What we're entitled to from this court would be declaratory relief, injunctive relief, and costs and attorney's fees. Now, the question I think Your Honor is getting at is, what exactly would that injunction say? Like, would the injunction say, go and sin no more? Or would the injunction say, go back and undo the previous damage that you did? Right? And what I believe the correct remedy would be, Justice Boyd, is to say that any adverse actions that you took after September 1st have to be undone. The contract was entered into before September 1st. So I would not go so far as to say that the court should order the city to undo the contract. What the court should do is order the city to reverse and undo adverse actions that it took to implement the contract.
But you don't know what those are yet.
We don't know what they are yet.
I'm sure there were some, but you don't know.
We're sure there were some. We just don't know exactly what they are. And again, as Justice Bland
Can you give me an
suggested,
example of what you think it might be?
negotiating with the replacement vendor would be an example, right? Because they were implementing the new contract that excluded Chick-fil-A. So anything they did after September 1st that would put someone other than Chick-fil-A in that spot would be an adverse action that excludes Chick-fil-A from a property or denies Chick-fil-A
So
access to.
effectively, they have to undo the amended contract, because what you're saying is you can't do anything that would put anyone in there but Chick-fil-A.
Right. Formally, you don't have to revoke the contract, but I think Your Honor is correct. It would functionally be something that prevents them from being able to implement the contract. But we're not suggesting the court has to, the court can't order the city
But
to rip up the contract.
Implementing
because-
a contract, even if I buy a car today and I agree to pay 15% interest in my contract, and tomorrow the legislature passes a law that says you can't charge more than 10% interest, you agree that I'm still bound to pay 15%?
No, well, you would be, we got to figure out exactly what the statute says. If it says going forward, you can't charge 15%.
Yes, it's not
Right.
retroactive.
Right,
Effective-
that's right. So it would be similar to what we have here. You
The
can't go.
contract's done. It may
Right.
be illegal now, but it's
That's right.
done.
So the contract is there, but they can no longer collect 15% interest on the contract. You're not entitled, however, to go get back the 15%
Oh, so
that
you
you
would think
paid.
that even if it's not retroactive, the law that says you can't charge more than 10% would retroactively change the interest rate I agreed to pay before the law was entered?
Well, I think the way I'm understanding Your Honor's hypothetical is there's a new statute that comes out after you sign the contract, right? That says no more 15% interest, 10% is the max, right? In that
Right.
situation, the contract still exists, all right? The contract hasn't been revoked, but they can't collect the 15% on the contract. Going forward, they can only collect 10.
So you
but-
think it would, okay.
Yeah, but you can't go back and sue to get the previous interest you paid before the statute's effective date. And that's similar to what we have here. And I think, to get back to your original question, and this is a complicated question of remedies, the only remedy we can get is to undo actions after September 1st. And because the contract was signed before September 1st, that's why I'm answering Your Honor's question to say we're not asking the court to force them to revoke the contract formally, even though I think Your Honor is also correct to say the remedy we're asking for is similar.
Effectively would.
It's effectively nullifying it because they can't do anything to implement the thing, if that makes
Mitchell,
sense. Yes.
what Texas case would you point us to that says that the legislature can abolish by statute the requirement of any injury at all? I understand the case is
Yeah.
about a particularized injury, and you can have we can have taxpayer standing, which the feds don't allow
Right.
by statute and all of that.
TTAM, all sorts of things.
But is there
Yes.
any case you would point us to that says the legislature can do that holds that the legislature can do away with any injury requirement at all?
There's a string of cases. I think it's hard to give you just one, but I would start with Spence against Fenchler from, I think, 1903, a very
Right,
early
but that
case
was a
with-
particularized injury case, right?
I don't believe
Or
so.
is that a public nuisance case?
It was more public nuisance, but you did not have to show injury, and the court actually specifically said there's no requirement of injury that needs to be shown because the statute lets anybody sue to enjoin the operation of a bawdy house, I believe it was. But then there's also Scott, which Justice Blacklock mentioned, Scott against Board of...
But that's a taxpayer standing case, right? So there was an injury because you're paying taxes.
There was an injury, true, but again, they explicitly said no requirement of standing, but there's Grossman against Wolf, which is a decision of the Third Court of Appeals that relies on the Supreme Court's precedents. But I think most importantly, to get back to a point Justice Blacklock was making, in most of these courts' decisions, when it talks about the need to show injury in fact, there is almost always a caveat that says, except when standing is conferred by statute. So it's making clear that even though this court is generally adopting the approach of Lujan with respect to the three requirements of standing, they're not going so far as to ban the legislature from conferring standing in situations where the legislature chooses by statute to confer standing on people who are not injured. And there are a couple cases where that caveat is not mentioned. And those are the cases Mr. Lane is relying on to say, look, this court is basically adopting the rule that Justice Scalia set out in Lujan, which is to say that these three requirements of constitutional standing cannot be altered by statute. But the vast majority of cases from this court, whenever they discuss those three requirements of standing, will say, unless standing is conferred by statute, and they specifically accommodate the rulings in Spence against Fenchler and Scott and Grossman against Wolf and those sorts of cases. So again, with all respect, I don't think there's a need, as Justice Blacklock was suggesting, to merge or blend those two lines of cases. In our view, they're all consistent. There may be one or two stray cases where they forget to mention the caveat. But in the vast majority of these courts' pronouncements, the caveat is there. And it's one of the many ways in which Texas standing doctrine departs from federal standing rules. As Your Honor suggested, this is not unique. Many other ways in which Texas goes rules that
Any
go
other
beyond
questions?
federal standard.
Thank you, Mr. Mitchell.
Thank you, Your Honors.
Case is submitted. That concludes the arguments in the cases set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.